My name's Leslie Fisk. I'm an attorney at South Carolina Legal Services. Other attorneys and I have prepared a few tips to help you be prepared for your order of protection hearing. We hope that the classroom you saw today gives you a little glimpse of what a hearing might be like so you feel more confident. When you're in an order of protection hearing, you need to use specific words about the abuse. And so what I mean by that is not to use words that could be vague, like he showed out or she came at me, because those could mean different things. You want to use action words such as punch, shove, slap, describe what happened, talk about where on the body you were hit if you were hit. Talk about your injuries. You can explain whether it was a closed fist or an open fist. If it's not too violent, you can show an example of the movement. But be very specific about that abuse. Also, even though custody might be your primary concern, you are filing this because you do need an order of protection. So it is very important that you first focus on the abuse and why you need the order of protection before you talk about custody. Because if you go right in talking about custody, the judge is going to be concerned that custody is your only reason for filing this and think that you don't really need an order of protection. So you first need to establish that you do need that order of protection before you start talking about custody. So once again, go over the specific words, the injuries, where you were hit, how it happened, what injuries you had. If you have photos, make sure you get those off your phone. You need printed photos. They could be either photographs or they could be copies printed from a computer, but the judge is not going to look at your phone, so make sure you get them off your phone. You should also bring a copy because the other side has the right to see a copy. If you have medical records, bring those and bring copies, but be aware that you might need to black out some important personal information, such as the address where you're staying, if you don't want the abuser to know that. Also, your social security number might be on there, so just be careful about what sensitive data might be on there. If there are any witnesses, you should ask them to come to the hearing with you. Let them know the hearing date as soon as you get it. Ideally, a witness would have seen the abuse, but we know a lot of times there are no witnesses to domestic violence. But there may be witnesses who called the police for you, or who you ran to a neighbor's house. They called law enforcement for you. They called an ambulance for you. Think carefully about who might be willing to testify that could help the judge make a decision about what happened and prove that you are telling the truth. Also, make sure you do tell the truth. You do not want to lie. Remember that what you say can be used against you in future hearings. Look at the judge when you're testifying or answering. You do not have to look at your abuser. You should know that the abuser or their attorney has the right to ask you questions. Just try to stay calm, answer truthfully. The judge will reel them back in if they're being inappropriate. But they do have that right, so I want you to be aware of that. Practice your testimony a couple times before you come to court. It may feel uncomfortable, but it's going to make your court experience better if you've done it before. Also, review your petition before you come to court, especially right before your hearing. You want to make sure that your petition and your testimony aren't contradictory. Be very wary if you're asked to agree to a mutual restraining order. A mutual restraining order is where both of you basically have an order of protection against each other. That might be the best thing for a few people, but for some people that can be a really damaging thing. It could affect your rights to carry a gun, as well as immigration relief. So ideally you would talk to an attorney about how that would affect your case, but beware about that. It's okay if you cry. We know that what you're talking about is very upsetting, but don't roll your eyes, don't interrupt the judge, don't do anything that could be considered rude. Make sure you answer all the questions out loud. Don't just nod or shake your head. The court reporter takes down everything that's said to keep a record. If at any point that you're uncomfortable and don't want to do this anymore, you can ask the judge, Your Honor, could you please withdraw my petition? And that means you're wanting the case to end. We wish you the best.